Well, I'm going to be two-fisted today, a microphone and a clicker. I can't tell you how happy I am to be here and honored, truly privileged to be with you. This is a wonderful symposium series. I've been introduced to some of the history of this, know some of the speakers who've appeared before, and it truly is an honor to be able to be here with you today. I want to commend Professor McGonigal-Smith and the students who are working on the research project that we heard about just a minute ago. I come from a program that's heavily graduate. We have a high number of master's and PhD students. Actually, Anna King is one of our PhD graduates, and Shad Maruna was on our faculty at the School of Criminal Justice for several years. So to use their surveys, probably not a bad starting point, but to have you all at this stage in your career doing serious, important work on an important issue is quite impressive. And I'll be interested to keep in touch with how you're coming on this research project. What I want to talk about with you is this death penalty issue. At first blush, it seems pretty straightforward. Somebody commits murder, is sentenced to death. You're either for it or against it, and you can probably say why you are. But I think it's important to probe beyond these general questions. And when you do, you learn that the death penalty as an abstract, principled enterprise is quite different from the death penalty as it's applied in practice. And I just want to explore some of the buried issues that may not be apparent on the surface about the death penalty, with the hope that it'll inspire some thinking and questions and discussion. I do want to leave a lot of time for your thoughts when I conclude mine, but I want to go in overview style, a little bit about the what is punished with the death penalty, who gets the death penalty, where, how we carry out the death penalty, why we do, and then I'm going to ask at the outset whether the death penalty makes sense as a criminal justice and legal policy, and I'll talk about a little bit about the implications of if the death penalty remains an institution within this country, where might that take us? And conversely, if it no longer remains in the future, what the implications might be. So what do we punish by death? I think the most fundamental aspect of capital punishment historically is that it has been very closely associated with preservation of state sovereignty. Death has been used to demonstrate the might of the state, sort of an in terrorem policy. If you threaten the security of the state, this may be what befalls you. Thus, crimes against the state traditionally have been punished by death: treason, espionage. Historically, several crimes were punished with death, and counterfeiting demonstrates that when the state itself feels threatened, and economic threat is a way that the state may demonstrate some vulnerability. I think this helps explain some of China's policies toward capital punishment, that there's a special need to react emphatically with the death penalty, perhaps. In the early 1800s, England, the country that our legal jurisprudential history is largely based on, implemented the Bloody Code, where well in excess of 200 different crimes were punished by death. And this was at a time of unrest in England, and again, suggesting the connection between the demonstration of state authority and the use of capital punishment. Now, we know, in part because the Supreme Court has told us in this 2008 decision, Kennedy versus Louisiana, and this is Patrick Kennedy up in the upper right-hand corner, who was convicted of raping his 8-year-old stepdaughter And it turned out this was not the first time he had raped a child. He had also raped another 8-year-old, and he was sentenced to death in Louisiana. And in a 5-4 decision, the Supreme Court said that our Constitution does not allow the death penalty for the crime of rape, and in fact, it is only those crimes against the state, as well as a very few crimes against persons, not rape, not even of a child, but only I just did something wrong, aggravated murder. So this gets us to, if we're talking about murder as being the only crime against a person that can be punished by death, we know that all murder shares a common characteristic, and that is the death of the victim. And all murder is inherently an awful crime. But it's not murder alone that merits the death penalty. It's only aggravated murder. So now we have to ask and be able to answer the question, well, what precisely is it that aggravates, makes one kind of murder more serious than another, so that it may deserve punishment by death? And it must have something to do with issues of individual culpability, the way in which a crime was committed, who committed it, who the victim was. We know, again, because the Supreme Court has told us, that you cannot automatically sentence anybody to death, no matter how heinous the crime is. Mandatory capital punishment offends the Eighth Amendment. There must be individualized consideration given to characteristics of the offender and of the crime. So a flat death penalty if you commit this crime is not constitutional. Those of you who were here during the first part of this conference heard a little bit about Furman versus Georgia, the landmark 1972 decision that said too much discretion offends the Constitution. It allows individual juries to make the most important of decisions, that between life and death, for reasons that may be woefully inconsistent, border on arbitrariness, include impermissible discrimination. So you can't just tell a jury, you decide whether this individual should be sentenced to death or not, and leave it to their own judgment. There must be some kind of guidance given to the sentencing authority to help them determine, is this crime committed by this individual appropriate for the death penalty? We know that no matter how awful the crime may be, some offenders in this country cannot be punished by death. Anyone who commits a crime who is younger than 18, mentally retarded offenders cannot be punished by death. The next class of individuals who we can predict will be challenging whether under any circumstances they can be sentenced to death are seriously mentally ill individuals who do not qualify for the insanity defense, are guilty of murder. But the question will be asked, is their culpability sufficiently heightened? Are they sufficiently blameworthy? Because they do have an illness that's somehow associated with what they did, so that whether they should be eligible for the death penalty. So we will be watching for developments about seriously mentally ill people. This is Troy Gregg, who is the protagonist in Gregg versus Georgia, which is the 1976 decision that the Supreme Court used to announce that the death penalty does not inherently offend the Constitution if it's administered appropriately. That is, discretion is given to the jury, but there is guidance, and you see some of the requirements of guided discretion. We need a relatively narrow class of crimes punishable by death. The jury must be guided by legislative standards. Death penalty trials take place as two trials. There's first a guilt-innocence determination. If and only if the offender is convicted of capital murder, do we begin a second hearing, and that's devoted exclusively to sentencing? Should this person get the death penalty or imprisonment? At that hearing, it's required that mitigating circumstances, that is, the offender's upbringing, whether or not the offender was under some kind of duress, suffering from mental illness, intoxicated at the time of the crime, somehow mitigate the seriousness so that not death but life imprisonment should be imposed. Now, it's something of a misnomer to talk about the death penalty in this country. Gregg versus Georgia actually was a compendium of 5 different cases and involved very different strategies that the states used to try to figure out who is an appropriate candidate for the death penalty. And the Supreme Court did uphold 3 significantly different ways of deciding who should live and who should die. These guided discretion statutes look elegant on paper. They are mostly characterized by definitions of murder and then a list of the considerations that aggravate a murder, a list of considerations that might mitigate punishment, and then the jury is told to consider, balance the aggravating and mitigating factors and thus determine who should die. There is a bit of slippage from time to time between the way statutes look on paper and how they're implemented in practice. For example, this attempt to regulate discretion in the capital sentencing process focuses exclusively at the tail end of a long, long process. Those of you here who are in criminal justice or have taken any criminal justice classes or know anything about criminal justice know that at the front end, enormous discretion is exercised that typically is not highly regulated, is not very visible, and what prosecutors do in terms of deciding who to charge with a capital offense is left totally unregulated by the so-called guided discretion sentencing schemes. If we do focus on the penalty phase of a capital trial, where again the thrust is to narrow the range of death penalty eligibility and to guide the sentencer in terms of, is this the kind of a crime, is this the kind of a person who should die? When you begin to look at aggravators, sometimes you question whether they're up to this challenge. For example, in California, there are 22 so-called special circumstances that define capital murder. And you have to wonder what's not included. If there are 22 different ways to commit murder and find yourself eligible for the death penalty, one of the special circumstances in California is called intentionally killed by means of lying in wait. And that is defined as any lapse of time, no matter how short, where the individual has an opportunity to think before committing a killing. And in practice, this category of killing alone comprises roughly 30 to 35% of murders in California. And that's just one of the 22. So you can, again, question about the success of the so-called narrowing function of some of these statutes. Another of the more prominent aggravating factors in death penalty statutes around the country is if the murder is committed in an especially heinous, atrocious, and cruel fashion. Now, you tell me what an especially heinous, atrocious, and cruel murder means to you. And if there are 80 people in this room, I would anticipate maybe 80 different definitions of heinous, atrocious, and cruel. And if these statutes are meant to guide discretion, again, you have to wonder whether we're able to do that with aggravating factors of this nature. The last of the aggravators up here is one of my favorites. At common law and in many death penalty statutes today, one way to get yourself in trouble for the death penalty is to commit perjury at a capital trial that results in the conviction and execution of an innocent person. And that seems to me to be a legislative recognition that as capital punishment is administered, there is a discernible risk that from time to time we may err, we may get some innocent people sentenced to death. Now, you all know that Texas is the nation's leader in carrying out executions. Far and away, you saw some statistics, again, if you were here in the earlier presentation, that in terms of states that execute, Texas is literally in a league of its own. It's carried out nearly 500 executions since 1977. The next closest state is far behind Virginia with 109, so it's qualitatively heads and shoulders above other states. And Texas uses a different way of deciding who should live and who should die. It's basically a statutory scheme that's predicated on future dangerousness. But again, when you take a closer look at the Texas statute, the second provision up there, the jury is asked whether there's a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society. So you're on a jury, and you're told, if and only if you conclude beyond a reasonable doubt that this factor exists, may the offender be sentenced to death. Now, this thing is sometimes called a definite maybe, because you need to believe beyond a reasonable doubt that there's a probability that what? The defendant would commit criminal acts of violence. What's that mean? It doesn't necessarily mean a repeat killing. The jury's not told what criminal acts of violence mean that would constitute a continuing threat to society. Now, what's that mean? Again, the jury's not told. We do know that since about 2004 or thereabouts, the alternative to capital punishment in Texas is life imprisonment without any possibility of parole. So presumably, continuing threat to society means a continuing threat to those who are incarcerated within prison, because there isn't a whole lot of chance that this offender is ever going to get out to be a future danger in our society. Now, guided discretion, which is constitutionally required, is meant to provide consistency to the way the death penalty is handed out. The court in Furman versus Georgia was troubled by the apparently idiosyncratic, arbitrary way in which capital sentences were doled out. So it said we need some consistency. However, a part of the guided discretion is that each and every case must be given individualized consideration by the jury, whereby the life circumstances of the offender and how the crime was carried out must be carefully examined to see if there are reasons that the death penalty should not be imposed. Now, can you achieve consistency at the same time you mandate that every single case gets individualized consideration for peculiar circumstances that might suggest that this offender does not deserve death? That's the conundrum, the logical apparent inconsistency that has led Justice Scalia to throw up his hands and say there's no way that these competing principles of consistency and individualization can simultaneously be accomplished. The very scheme that we on the Supreme Court have designed has an inherent flaw, a defect, and Justice Blackmun agrees. At the very end of his tenure on the Supreme Court, Harry Blackmun was appointed to the court in 1971. At the time, he voted to uphold capital punishment in Furman versus Georgia. He was one of 4 dissenters. He was with the majority in 1976 when the court approved capital punishment under the guided discretion scheme. By the end of his career, observing case after case after case under this model, he also concluded, as Justice Scalia did, that the system wasn't working. But the implications were quite different for him. Justice Scalia said that he would no longer vote to uphold this individualization requirement. And that's how he attempted to reconcile it. Blackmun came to the conclusion that he would no longer, in his famous words, tinker with this machinery of death which was broken, and he vowed never, as long as he sat on the court, to vote again to uphold the constitutionality of a capital sentence. Now, he retired from the Supreme Court roughly 2 months after he made that announcement, but that was Justice Blackmun's conclusion. If we have this elegantly designed capital punishment system that's been carefully put on paper, thought through with narrowing, guidance, some measure of discretion, etc., who do we depend on to implement it? Juries. Now, some of you in this room, in this state, conceivably, could be called for jury duty in a capital case. That's quite a responsibility. Some of you in this room, if called to serve in a capital case, would be told, we don't want you. You cannot participate. And that's because some people, for moral, religious, philosophical, or other reasons, believe so strongly about the death penalty that they will not make their personal views secondary to what the law requires. People who feel so strongly that the death penalty is wrong that they could not follow the law that requires them to consider sentencing another individual to death are not death qualified. And we know that, I don't know, this will be perhaps one interesting result from the survey that the students who spoke in the first segment of this may find. We know that nationally, somewhere in the ballpark of 14 to 20% of individuals are not death qualified, so they can't serve on capital juries. We know that attitudes about the death penalty nationally correlate with certain demographic characteristics, including race and gender. So we know that the death qualification process systematically excludes more African Americans than Caucasians and more women than men. There is a certain percentage of people, it's typically somewhat smaller than those who strongly oppose the death penalty, who so strongly support capital punishment that they believe in literal eye for eye retribution, that if you kill another person, you should be sentenced to death, no further questions asked. This group is not life qualified because they would not fairly consider the option of life imprisonment. Now, the reason that some of you in this room wouldn't be allowed to serve on a capital jury because of your attitudes about the death penalty have to do with the requirement that both sides, both the defense and the prosecution, are entitled to an impartial jury. And that means a group of people who are willing to follow the law and base their verdict on what they hear in the courtroom, the facts and the judge's instruction. And if you're not willing to follow the law, you're not an impartial juror. Now, this mandate for an impartial jury collides with another principle of juries, which is that they should reflect a fair cross-section of the community. So if a substantial portion of the community, and I'm going to use perhaps 20 to 30%, combining the non-death qualified and the non-life qualified people, can't participate in a capital jury, in the interest of getting impartial jurors, we're losing the opinions of quite a considerable segment of the community. And that's another of the paradoxes of these capital punishment laws. We also know from research that, try as they might, many jurors simply do not comprehend the judge's instructions, and by the time they get back into the jury room, it's as if the law as written on paper doesn't exist, because they're talking about issues that have nothing to do with the law. And we know this from research done by the Capital Jury Project, which is based on interviews of more than 1,200 people who've served in capital trials that have taken hours and hours to conduct. And that's how we learn what happens behind those closed doors. And that's another kind of a slippage point between the law as written and the law as applied. With respect to the where of capital punishment, we heard earlier, again, if you were lucky enough to be here earlier, a little bit about the international picture of the death penalty. Alan Clark will be talking about this in much greater detail in our next section. But as you heard, the United States is now among a distinct minority of countries where the death penalty is carried out. Certainly among Western industrialized countries is an outlier. But even to generalize about the United States being a country that carries out the death penalty is too broad. 33 of the 50 states authorize the death penalty. 1 out of 3 states in this country have abolished capital punishment. So the country, as a country, is not necessarily a death penalty country. And when we look at the states that use the death penalty, this is a little bit dated, 2009, but these are executions. This is Texas. And now the curve goes, and to say that 33 states authorize the death penalty misses a lot of the enthusiasm for capital punishment displayed by many, many states. New Hampshire, for example, is one of the 33 states with capital punishment. Well, they haven't carried out an execution since 1933. So does it make sense to talk generally about the 33 states, or must we go state by state and then begin to think, is this a death penalty country or not? And that's not the end of the complexity of these issues. Even to talk about states is to overgeneralize. This is Texas. Texas is the king of capital punishment. Most counties within the state of Texas have never sentenced anybody to death. Harris County, which is Houston, is responsible for sending more than 300 offenders to death row. So we can't even talk about Texas as an entity without being further discriminate about, oh my golly, I did it again, the death penalty. And this is a very fruitful area for additional research. Surprisingly, in a big study that followed the death penalty through the mid-90s, 60% of the counties in capital punishment states never sent anybody to death. Over half of the nation's death sentences came from 2% of the counties within the United States. And more recently, in this very good law review written by Rob Smith in the Boston University Law Review, who's updated it, we now know that 1% of the counties in the United States of America are responsible for dispatching 44% of death sentences. The leading county in 2009 was Maricopa County in Arizona, which is Phoenix, where 11 death sentences were handed out, which exceeds the entire total of the state of Alabama, which is another pretty prolific death penalty state. So as we think about capital punishment and the country and the states, it's increasingly important to understand what's going on at a county level and to explain why there are such differences in individual counties. Another problem area in the death penalty historically has been the issue of race. Again, the laws as written are neutral. They are indifferent to race. Historically, race has been inseparable from the death penalty. In more recent times, the United States Supreme Court has considered a challenge from the state of Georgia, the state that gave us Furman versus Georgia and Gregg versus Georgia, to examine whether the law as written was fairly administered in practice with respect to race. And this decision in McCleskey versus Kemp involved a black man, Warren McCleskey, who was convicted of murdering a white police officer, Frank Schlatt, and sentenced to death in Georgia. And the decision was based on a large-scale study, and this again suggests the importance of empirical research in the death penalty area, of homicides in Georgia, those that were charged capitally, those that resulted in a sentence of death. And the study found, perhaps surprisingly, that race of defendant made relatively little difference with respect to who's getting a death penalty in Georgia. However, when the race of the homicide victim was examined, overwhelmingly, death sentences were reserved for white victim killings. In raw numbers, if a black defendant killed a white victim, those cases resulted in a death sentence 22% of the time. If a black defendant killed a black victim, those cases resulted in a death sentence 1% of the time. There are striking disparities. McCleskey essentially argued that in the state of Georgia, a black life is worth less than a white life. If a black person's killed, it's not a dramatically serious event in the state of Georgia, but heaven help you if you kill a white person. That is serious. Now, might there be racially neutral, legitimate explanations for the disparities we see? And it's possible. Maybe when a black kills a white, there's less chance that the defendant and victim know one another. And stranger killings are considered more frightening, serious than homicides among intimates or acquaintances. Maybe more of these killings took place during the commission of another felony, like armed robbery or rape. And maybe it's these non-racial reasons that explain the dramatic differences. Well, the researchers took account of that. They measured something like 230 case variables for all of these killings. They performed statistical analyses and demonstrated that in otherwise identical killings, everything's the same, except the race of the victim. The odds of getting a death sentence are 4.3 times greater if you kill a white person than if you kill a black person in Georgia. Now, is this sufficiently troubling to undermine the integrity, the constitutionality of the death penalty? The Supreme Court said no by a vote of 5-4. Many people agree with that. Ernest van den Haag is one of those. Professor van den Haag he's no longer with us, but he was one of the most articulate spokespeople in support of capital punishment. And he said that unequal justice is still justice, that people like Warren McCleskey are no less guilty, are no less deserving of a death sentence, simply because other people, i.e. those who kill blacks, are not getting the death penalty. He analogized it to driving, and if we got a black driver going 80 miles an hour in a 55-mile-an-hour zone, and a white driver going 80 miles an hour in a 55-mile-an-hour zone, the black driver shouldn't be heard to complain when he gets pulled over for speeding just because the white person didn't. It doesn't make him any less guilty of speeding. He's still speeding. That's the van den Haag thesis, that unequal justice is still justice. The counter-arguments that are often advanced is, well, race is such a dramatically important variable that de facto it operates as if it's a statutory aggravating factor. You might as well write into the statute that if you kill a white person, that's a good reason to consider this a more aggravated killing. Now, would we stand for a death penalty law that built in on its face race of victim being a legitimate consideration in terms of a sentencing decision? This is not as far-fetched as you might think. In the period right before and after the Civil War in this country, several states did have the so-called black codes, where if you were black and you committed the same kind of a crime that a white person did, you and you alone, i.e. the black offender, was eligible for the death penalty. But I think pretty clearly we would not tolerate race as a statutory aggravating factor in this day and age. Are there ways to support the death penalty and still be concerned about this racial factor figuring in? Well, potentially yes. Suggestions have been made that if the range of capital crimes is narrowed to include only the most highly aggravated kinds of killings, that race is going to fall out as a significant variable. A lot of the racial variation happens during the prosecutor's charging decisions, which are totally unregulated. And some people have suggested we need a centralized, regulated way of getting to who prosecutors are charging in capital crimes, that if we start to examine those decisions, we may have better luck with squeezing race out of the picture. And finally, the composition of capital juries, which in part because of death qualification, in part because of peremptory challenges, tend to be predominantly white. If there were a way to get more balanced juries, perhaps some of the racial problems would go away. Now, another of the clear issues surrounding the death penalty in this day and age is the threat to innocent people. Justice Scalia, again, in a case decided just a few years ago, is skeptical. He's suggesting his skepticism about whether an innocent person, in fact, has been executed in the modern era. of capital punishment. We know, and again, in the earlier presentation, that in the modern era of the death penalty, there have now been 141 people who've been sentenced to death, spent years on death row. I think the average is about 9.5, 10 years, before it was discovered that they were factually innocent. There is some controversy about whether all 141 are in fact factually innocent. There is no doubt that many of them are factually innocent. Several of them came within hours or days of execution, and those executions didn't take place for fortuitous reasons. Journalism students who were investigating, or we need to examine the offender's mental status. Without those stays, a few of the individuals would have been executed. There is a suggestion now that indeed innocent people have been executed, not just sentenced to death, but executed. Cameron Todd Willingham, the man in the upper right there, was executed in Texas for the arson murder of his 3 children, who died in a house fire in which Willingham lived with his wife and children. The case was tried in the 1990s, and support for the theory that the fire was arson was based on the opinions of fire investigators who do things that I don't know how it works, but it's smoke patterns and various inferences made on the physical evidence that is left in the wake of a fire. And the experts testified that the fire was of a suspicious origin in their opinion. Right before and then after Willingham was executed, the same evidence was subjected to re-examination in light of what forensic scientists now consider to be the reliable science of arson investigation. And an independent panel concluded that there was no basis for the conclusion that the fire did start by arson. Willingham protested his innocence throughout his trial. His last words before being executed were, "You are executing an innocent man." More recently, Jim Liebman at Columbia Law School and several law students have come out with a book-length exposition about Texas's execution of Carlos de Luna. And in their view, another man named Carlos Hernandez, was the responsible party for the murder, and they amassed what seems to be very persuasive evidence that it was erroneous eyewitness identification. You can see there's at least some resemblance that the wrong Carlos was convicted and executed for a murder committed by Carlos Hernandez. Now, what do we do about innocence? What Maryland has done is quite interesting. Maryland, in 2009, revised its death penalty statute in order to try to guard against the risk of innocent people being executed. And they did so by saying that if and only if biological or DNA evidence supports guilt, or there's a videotaped voluntary confession, or a video recording of the crime, only on that proof can a person convicted of murder be sentenced to death. So this is in order to make sure we have the right person. Now, should we move in a direction like that, think about the implications of this statute. Think about people who, if you support the death penalty, you probably want to see get it. Osama bin Laden, Timothy McVeigh. These are not cases where you're going to find a videotape confession, a videotape of the crime being carried out, or DNA evidence. They would not be eligible for the death penalty under Maryland's reforms. It's another paradox. Can we simultaneously guard against executing innocent people and get the kind of people who, for retributive reasons or deterrent reasons, most deserve capital punishment. One of our candidates for president, while he was the governor of Massachusetts, ordered a special commission to design a death penalty statute that, insofar as humanly possible, precluded the risk of executing an innocent person. And the Romney Commission did require conclusive scientific evidence, no doubt about guilt, crafted a very narrow death penalty statute. So what I'm suggesting again is that if the death penalty is a part of a state's jurisprudence, and if innocence is an issue of concern, there may be reforms that could or should be considered, although some of them may be more satisfactory than others in terms of promoting other objectives of the death penalty. So now the how of capital punishment. We've moved beyond the years of horrific boiling in oil. This is an offender being drawn and quartered. They used to tie them to 4 horses and point the horses in different directions and say, "Giddy up." And that was the quartering. And there are other very grisly ways of carrying out executions. In my state of New York, the governor in 1888 got together, how would you like to be a part of a commission like this? A commission designed to study the best way of putting somebody to death. And this commission, you gotta like governmental commissions, alphabetized 34 different ways of carrying out executions historically. And they started with auto da fe, which was burning people at the stake. And they ended with suffocation. And they considered a wide range. And they concluded at the end of their deliberations that, well, maybe this electricity innovation, and that gave birth to the electric chair, and the first electrocution was carried out in New York in about 1890. Nowadays, lethal injection, of course, is the execution method of choice in all of the states that administer the death penalty. It's the primary, if not the exclusive way of sentencing people to death. Ronald Reagan was somewhat ahead of his time while governor of California, suggesting that maybe this would work. Earlier this year, Clint Eastwood, among his other distinguished contributions to our politics, has suggested that, basically battery acid would work as well as anything else in terms of trying to carry out lethal injection. Now, is lethal injection a more humane and foolproof way of carrying out the death penalty than firing squad, hanging, electrocution, gas chamber, etc.? It may not be as clean as Governor Reagan thought. For example, just 2-3 years ago in Ohio, Ronald Broom lay on the execution gurney for in excess of 2 hours, while so-called execution technicians, because for the most part, people in the medical profession, doctors, nurses, are bound by ethical codes that prohibit them from participating in executions. Theirs is a healing profession, not a killing profession. So for the most part, not exclusively, doctors, nurses will not take part in execution. So trained technicians do. They tried for 2 hours to find a suitable vein in Broom's arms and failed. So they had to call it after fishing for 2 hours, and he was taken back to his death row cell because they were unable to carry out the execution, and he still is awaiting word whether a second attempt to put him to death would or would not be permitted. The way that lethal injection is designed to work in the 3-drug protocol, as you may know, is that the first drug administered is a sedative. If any of us has an operation and it's going to be put to sleep, and I mean sleep, where hopefully you got a good technician working with you, you'll be given a sedative, so you are put unconscious while they're cutting on you. That's step one. Step 2 is a paralytic drug that arrests muscular movement, including the ability to breathe. And then the third drug causes cardiac arrest. And if administered sequentially, it all works nicely in most cases. But we can infer from autopsies that it doesn't always work. And the consequence is that the sedative wears off while the paralytic drug remains in effect. So the person appears to be unconscious and cannot move, but is fully sentient and able to experience what's going on, and does experience the exquisitely painful inability to breathe, and then the consequences of the drug that cause cardiac arrest all the time. They appear to be under the influence of the sedative. So that is a problem. The Supreme Court approved lethal injection in a case from Kentucky, decided 4 years ago, and it turns out, and this is another of the potential paradoxes of capital punishment, that the second drug, the paralytic drug, is designed mostly for our benefit. That is, the benefit of the witnesses to the execution, because absent that drug and absent the third drug, the death process can go on for a lengthy period of time, perhaps up to 25 minutes, and it includes a number of rather unsightly muscle spasms, the so-called death dance, and the witnesses thus are subjected to a lengthy execution process where the person is twitching around, and these drugs are designed in large part, again, to protect us from the consequences of execution. And this whole question of how we execute has given rise to others to question whether we should execute, and this is Justice Stevens. And somewhat like Justice Blackmun, Stevens was appointed to the Supreme Court back in 1975. Like Justice Blackmun, he originally voted to uphold the constitutionality of the death penalty. And like Justice Blackmun, at the conclusion of his career on the Supreme Court, 1975 to 2008 is what, 33 years of looking at death penalty cases. Justice Stevens also threw up his hands and said, I've been watching this too long, and I have come to the conclusion that we cannot constitutionally carry out capital sentences. Stevens felt bound by precedent, but again, it's interesting that those who have been designing the system, watching it very closely, are at least skeptical in some circumstances about their work product. Now, quickly, why do we have the death penalty? I'm not going to belabor you with the obvious. Retribution is you kill somebody, you deserve it, just desserts. Deterrence is we're going to carry out this execution with the hope that it will discourage other people in the future from committing murder. But note that deterrence presumes that the death penalty is better than an alternative sanction. Now, I might ask, I'm going to take my own survey of people in this room, and I might ask how many people at 11 o'clock or 11:30 are going to go out and kill somebody. I'm not seeing any hands. That's good. Now, I'm going to ask you why. And I bet you nobody is thinking, because if I kill somebody, I'm going to get punished and I might get the death penalty. You're not thinking that, are you? For the most part, our restraints against killing people are internalized. We won't do it because it's wrong. Now, can you imagine people who are deciding whether or not to kill based on what punishment they're going to get? Now, that presumes I'm thinking of killing somebody. Uh-oh, I might get caught. I might get convicted. I might get sentenced to death. I better not do it. Now, that's not quite what deterrence means in this context. In this context, it means, what? You're only going to send me to prison for the rest of my life, life without parole? No problem. I'm going to go ahead and kill. It's if and only if you threaten to execute me, I will be deterred. So it requires some rather substantial assumptions of a rational offender who's thinking about punishment, who's willing to accept life without parole, but will only be discouraged if the death penalty's awaiting. Is there evidence to support this? Earlier this year, the National Research Council did an exhaustive review of available studies on the death penalty. Logically, you could see why questions might arise. They concluded that there really is no research that is informative, sufficiently informative one way or the other to inform the death penalty decision. Now, as for retribution and deterrence also, in principle, we can debate whether these objectives make sense. We really do, though, have to look at the death penalty as it's carried out. A famous quote from Foreman versus Georgia, Justice Stewart evokes the metaphor of being struck by lightning. So, interested in that proposition, I tried to figure out how many people are killed by lightning in this country and in Utah specifically, and measure that against the death penalty. And basically, since 1976, this country has, seen tragically 670,000 criminal homicides. 7,700 people have been sentenced to death. That's 1% of criminal homicides result in a death sentence. We've had this many executions. That's 0.2% of individuals who commit a criminal homicide are executed. And you can see that in terms of executions per year versus being killed by lightning per year, that lightning is somewhat ahead of executions as a way of causing death. Those of you who live here in Utah on a year-round basis, you're fairly high in terms of lightning strike vulnerability, so watch out when you go outside during inclement weather. You might get struck by lightning. Here's how we're looking in Utah here, going back to 1959. Your crime statistics suggest that you're a very low crime state, by the way. Congratulations, keep it up. That's what we like to see. But 2,200 people died by criminal homicide since 1959, 1,700 since 1977. You've had 8 executions, 52 people dying by lightning. You've had 7 executions in the modern era, and that means that in terms of criminal homicides, executions, 0.4% of offenders are executed. Now, what are the implications of this in terms of the death penalty's ability to promote the objectives of retribution, deterrence, if we're worried about murderers killing again, if we're concerned about victims' families, what are the implications of 99.6% of criminal homicides are not punished by death? What kind of a message does that send to victims' families? Does that possibly promote the objective of retribution or deterrence? As a practical measure in terms of promoting criminal justice policy, if we're getting 0.4% of murderers, this ain't, and you don't need a PhD to make this statement, this is not a system that's going to promote deterrence or retribution or serve victims or incapacitate people when 99.6% of the people who commit these crimes don't get the death penalty. But the death penalty must be serving some function. If it's not a practical policy function, maybe it's a symbolic function. And from my way of thinking, this is what the death penalty is all about. Symbolically, When we sentence somebody to death, that's an emphatic statement that good is prevailing over evil, law and order is prevailing over criminal violence. It helps assuage fear. David Garland has written a very provocative book that suggests that capital punishment is another way of the states kind of flexing their states' rights muscles in the wake of federal authority, and it is one way, in Garland's opinion, of responding to perceived racial threat without using those words. Now, if the death penalty, and you may or may not agree, but I'd be interested, is largely fulfilling symbolic rather than practical functions, there is an emerging counter-narrative that seems to be taking hold these days, and the counter-presentation of capital punishment associates it with issues of innocence, racial discrimination, arbitrariness, excessive economic costs, the United States being out of touch with what's going on in the international community. And this counter-narrative is almost certainly responsible for what we're seeing, a remarkable mini-trend with New Jersey, New Mexico, Connecticut, Illinois repealing their death penalty statutes within the last 5 years or so, a dramatic reduction in the number of new death sentences handed out. In the mid-1990s, well over 300 people a year were being sentenced to death in this country. Last year, 78 people in the whole country were sentenced to death. Only 8 people in the whole state of Texas were sentenced to death last year. There's something remarkable going on, from over 300 as recently as 15 years ago to 78 last year. Now, if the death penalty is going to remain a part of the American landscape, we have a number of questions to confront. Are there going to be executions? If so, will that convert the symbolic significance of the death penalty to something that some people don't want to see? There are 725 people awaiting execution in California. 14 people have been executed in California since the late 1970s. This is a tremendous backlog. Is California going to execute all those people? Are we going to promote any permissible objectives of punishment? Will these disparities continue? If the country or if states are moving away from the death penalty toward alternative sanctions, that means life without parole. And those of you interested in studying or thinking about criminal justice policy or issues should start to think about studying life without parole and what life might look like without the death penalty. Will crime rates change? Is the death penalty used as a bargaining chip? Right now you have the death penalty in Utah. If I'm a prosecutor, I can tell a defense lawyer, look, I'm going for the death penalty unless your client pleads to murder for Elwha. Now, if the death penalty were to go away tomorrow in Utah and I'm a prosecutor, I don't have the death penalty as a bargaining chip. Is it ethical to use capital punishment to bargain? Will fewer people plead guilty to capital murder without the death penalty? This is one of the most widely asked questions in the post-abolition states. Will there be cost savings? We can predict that the answer is yes. If so, can we divert those resources elsewhere? To victim services, to law enforcement, and so forth. A part of your program today is going to focus on restorative justice. I come from New York, where David Kaczynski, the brother of Ted Kaczynski, the Unabomber, has done a lot of work with the death penalty, and it's David Kaczynski's view that we don't have the death penalty in New York anymore. We did as recently as 2004. When it was taken off the table, David found that it made it so much easier to bring people together from all political spectrums to talk about what really needs to be talked about in David's opinion, which is the causes of crime. We all can agree that education's a good thing, that youth gangs are a bad thing, that too many guns on the street are a bad thing in the wrong hands. And he found that law enforcement were willing to sit down with community activists and social workers and had a lot more in common when they weren't bickering about the death penalty. From a legal perspective, the death penalty has driven a lot of constitutional doctrine, including most recently when the death penalty went away for juveniles in 2005. It led to more recent decisions about life without parole not being appropriate for juveniles who do not commit murder or who do commit murder if it's mandatory. If capital punishment goes away, some people are suggesting, ironically, that the law may become more static. If the death penalty goes away, will there be impetus for systemic reforms? Governor Ryan in Illinois commissioned, we know that in Illinois, that state saw 13 people released from death row who were innocent, while 12 people were executed. That's not a very good batting average, is it? Governor Ryan said, not under my watch. He issued a moratorium. He commissioned several people to think about reforms. How are we going to stop this? And lo and behold, all of the reforms suggested for how do we avoid miscarriages of justice in capital cases applied to non-capital cases. Now, without the death penalty to help drive issues like this, might we all relax and take life a little bit easier outside of this very narrow range of capital punishment? These are the Scottsboro boys. I think in 1936, the New York Times got it right. One of the Scottsboro boys, Haywood Patterson, had been like his colleagues. These guys were convicted of rape in Alabama, 9 of them. 8 of them were sentenced to death. They were all between 14 and 19 years of age. Their case is one of the most famous in all of the annals of jurisprudence about miscarriages of justice, capital punishment, and so forth. Eventually, in the mid-1930s, the death sentences went away after many years on death row. And will we fall prey to this tendency to, oh, this individual's not under sentence of death, so what's the big deal? Would Troy Davis have commanded national attention if he had only been sentenced to life imprisonment? Would anybody really care? So this is my last slide, and I've talked too long, and I'm sorry for that. But there's a lot to be done here. I want to leave you with this thought. It's attributable to one of these TED lectures that you can watch that David Dow gave, who's talking about the death penalty. And what Dow said was, this is a bunch of complicated issues. As with some complicated issues, the way to get a handle on it is not to micromanage, but to ask bigger questions, make the question bigger. At a minimum, we can all agree that we'd rather not be thinking about the death penalty. It would be so much better if we could prevent these murders in the first place. So those of you interested in criminal justice, don't spend all of your time thinking about the death penalty. Ask bigger questions. What can we do as a society, as a state, to implement policies that will help forestall the commission of murder and not require us to preoccupy ourselves with these questions of punishment? I've gobbled up all of my time, but with your permission, I'm going to stop and hope that we have a little time for questions and comment anyway. So please, anything at all on your minds, I'd love to hear about at this point. Yes.
You seem to draw a strong connection between racism in the South and execution. Are these results of old legislation legislation that just hasn't been reformed, or are these sociological factors using jury prosecution discretion and impeachment?
Yeah, the race issue has been studied in multiple jurisdictions, from the southern states to New Jersey to California to Illinois, and with remarkable consistency, not always in the same degree, there is a finding that white victim killings tend to be treated more seriously in the death penalty context. In Philadelphia, it was black offender killings, the young black male stereotype, that seemed to be driving death penalty decisions. Again, this is when legally permissible race-neutral factors are controlled for. And the explanatory reasons include the media, which tends to give greater publicity to a killing of a white person, especially if they're of an upper socioeconomic status. That's going to lead the 6 o'clock news. If we have a killing of a person of color in a less wealthy part of town, housing project, for example, that's going to be buried in page 23 of the newspaper. And to the extent publicity drives prosecutions and public opinion, that's a factor. As you suggested, it's the composition of juries, it's prosecutors' assessment of. So there's kind of a self-fulfilling prophecy. If I'm going to invest all this time and resources in a capital prosecution, I want to make sure I'm going to get a death sentence. What kind of a case is most likely to result in one? Well, it's probably the high publicity case that's tried before a predominantly white jury that involves a white victim. So for multiple sociological and legal reasons, this phenomenon tends to not be confined to the South. But again, that's another reason to do state-specific research. Whether this is part of Utah's experience, as far as I know, is an open question. So it needs to be carefully examined. Yes?
I guess this question is going to be about the connection between logic and maybe morals and ethics.
Uh-huh.
So this presentation seemed to be, to me, pretty convincing that logically, you know, that because our laws and because the people that uphold the laws are imperfect, that it doesn't seem very logical to uphold the death penalty in most cases. So can you legally say that, well, I just morally believe that this is correct, that we should do that based just purely on morals, or is it our logic that would tell us whether or not our morals are right or wrong? Does that make sense?
I think so. The law, as lots of people point out, is not divorced from morality, and in fact, it's one way of our announcing to ourselves what moral values we hold most highly. So there's not intrinsically a conflict between legal and moral judgments, and in fact, from a constitutional perspective, the Supreme Court tries to measure indicators of public attitudes, such as legislation and jury sentencing behavior and history, that are informed by the collective moral judgment of people. So I guess there's no war between law and morality, and you can come at the death penalty, and probably most, if not many people do, from a purely moral perspective. It's right or it's wrong. That judgment, in my opinion, is better informed not just by looking at the big principles, but again, the death penalty as actually carried out in practice. Now, is that a system that you can feel from a moral perspective is defensible? If morality is a part of your decision, fine. Perhaps utility is another part. And then we ask, is it cost effective? Is it riddled with problems? Are we getting the right people? Are we getting race out of the system? And thus, to me, it becomes a combination of prioritizing ideals and what you want to promote logically from a policy perspective.
So you could legally say, well, we believe that morally this is going to be a symbol of, I don't know, a symbol that good will beat evil or something like that, and therefore constitutionally or legally or however.
No, I think some writers are very comfortable with that. One of the most, again, articulate is a fellow named Walter Burns, who wrote about the morality of anger. And in his view, the society would be disserving the lives of innocent people and the value of human life if it reacted less forcibly than capital punishment in response to the claiming of an innocent life. Burns said, we daggone well ought to be mad about criminal homicide. And we need a way of reassuring ourselves that we're all on board with this, and to do less than the death penalty is indefensible in his view. So I think you can make the argument that from a moral perspective, the death penalty is an imperative. Certainly some philosophers have thought that. Other people will say that no, the government simply should not go to the extent of claiming the lives of one of its citizens, and then we're into that debate, which is something that all of us probably need to wrestle with on a fundamental level. Yes?
So you said that there's a trend like decreasing away from the death penalty, and so my first question is, why do you think that is? And the second question is just more, do you think that the United States will eventually completely be done with the death penalty?
There is a trend. We can say that. If you saw the execution chart, if we think about the number of individuals being sentenced to death, which is down, 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 if we look at recent states abolishing the death penalty, if we look at legislatures that are considering doing so, at least in the, it's difficult to, it's always easier from a long historical perspective to look back on these, but it appears that something is going on, and the something usually is explained as a combination of variables that include, right now, crime, and the crime rate is not a salient political issue. We're all talking about the economy. We're talking about wars overseas. To some extent, drug-related killings, which peaked in the 90s, have diminished. And so crime is not a front burner on the political agenda, and the extent to which the death penalty does symbolize law and order, good versus evil, there's less discussion about that. But there is increasing agreement that these death penalty systems are astronomically more expensive than simply maintaining a system that's premised on life imprisonment, and in part because of economic concerns, and realizing that we're investing all this money on a policy that doesn't do a lot of good in a lot of people's opinion, and that money could be used for education, healthcare, law enforcement, victims. Are we making wise investments? And then innocence, an issue that troubles a lot of people, the fact that several exonerations have been based on DNA. It puts right there undeniably that we've gotten it wrong and have come this close, if not executed, innocent people. And finally, the emergence since the mid-1990s of life imprisonment without any possibility of parole as an alternative. Before then, there was parole eligibility in almost all states, and there was a concern that they might get out, that that's not just. I mean, you kill somebody and you might be out in 20 years, but now virtually every death penalty state has life without parole as the alternative. So it's all of this in combination, and the international climate, where we're increasingly out of step with our neighbors, that I think is leading a lot of people to re-examine this policy at this time. Yes?
Could you explain why life imprisonment costs more than sentencing someone to death, putting someone to death?
Yeah, it's the other way around, though. It's complicated. Everybody gets excited when a capital prosecution begins because so much is at stake for both sides. So the pretrial process is extensive. In most states, not one but two attorneys that are especially qualified are appointed for the defense. They will enlist investigators and experts just so every I is dotted, every T is crossed. So we have a big build-up pretrial. The jury selection process, which includes this death qualification, life qualification, and usually more peremptory challenges, can take not days, but weeks, sometimes several weeks, to pick a capital jury. Well, then we have an extensive guilt trial. And if and only if we get a capital murder conviction, will we begin a separate penalty trial, which again, if done right, is going to be time-consuming and involve psychiatric and social work and other testimony. So we have two trials then. This is all expensive. We know that in roughly 50% of capital trials, the jury comes back with a life sentence. So immediately, your investment is paying a rather 50% return. From that point, the appellate process begins. And now, the average stay on death row between conviction and execution is about 14.5 years. In that process, we know from the Liebman study, A Broken System, that between 1973 and 1995, two out of three death sentences imposed were thrown out. Now think about this. Well, this is expensive. We're only getting 50% death sentences. Of those death sentences imposed, 2 out of 3 are thrown out. Beyond that, offenders are under special supervision on high security, expensive death row incarceration. You got a state like California, 725 people on death row, some of them there in excess of 30 years, 13 executions. So when you start to calculate the pretrial, the trial, the fact that most death sentences are not imposed or carried out, the extensive incarceration, it's most state, hundreds of millions of dollars more expensive than if death is off the table, the maximum punishment is life without parole. Typical estimates of incarceration costs are $20,000 to $35,000 a year, so you multiply that times 40 years of a life sentence, that's $800,000 to $1 million of incarceration costs, but death trials and the whole process costs, millions of dollars. So that's the reason most people say, most studies in most states, and Utah will be interesting what your conclusion is, that the death penalty is more expensive than a system based on life imprisonment. I'm thinking I'm apologizing. Thank you so much for your attention. And